The second paragraph, in order to determine whether probable cause existed at the time of the defendant's arrest, we must follow the applicable standards set out by the Supreme Court. So they're looking up at the Supreme Court, and what does the Supreme Court say? What's the rule?
Probable cause exists where officers think it's reasonable.
Yes, where officers think it's reasonable. Officers have a reasonable belief that a crime has been committed. So they give us the facts, the issue, the rule, and then what? Bottom paragraph, repeat that. The very last paragraphs. Read, please. Yeah, we now must
Now must apply the standards initiated above to the particular facts and circumstances of the case before.
Okay, we must apply the rule to the facts. We must apply the rule. Probable cause exists where there is reasonable suspicion. We must apply that rule to the facts of the Elroy and Bobby, to the facts of the Lewis brothers, to this particular case. So we're going to apply what the Supreme Court says. Now let's read that again. Let's read how they apply it. How do they apply it? Let's read.
Upon cause inspection, the court reveals two police officers responding to a ready.
There's two conclusions, really. You only have to know one, but you can give me two if you want. The first conclusion is probable cause existed. The officer's actions were reasonable. And that's why probable cause is the heart and soul of search and seizure. It's the heart and the soul of all of this that we're discussing. It's the most important term when we're discussing Fourth Amendment rights. If it appears from the complaint that probable cause exists, if they write out the facts, dear judge, it is my belief that probable cause exists for this investigation. I would like to search Bob's house. Well, why do you want to search Bob's house? Why? Well, I received a letter. And he'll look at the facts. Well, what do you have here? What kind of facts do you have that support probable cause? What facts are in this complaint that show me that you have probable cause to go over to Bob's house and break his door down and go in there with guns and arrest Bob and pull him out? Well, Your Honor, we have a letter. What kind of letter? Well, it's just a letter. Somebody says Bob's a drug dealer. I received the letter in the mail. Well, who's the letter from? I don't know. What does the letter say? It says he's a drug dealer. It says he's got drugs in his house. Anybody. How do we determine whether it is reasonable to use a letter, an anonymous letter, to go search somebody's house or not? If you just have one letter, that's all you have. Nothing else. Because sometimes there aren't going to be witnesses. Sometimes there won't be any witnesses, like we had in Elroy, like we had in Lewis. That's a black and white case. But some cases, most cases are not black and white. Most cases you will not have a witness number 1, or 2, or 3. Most cases you will not have the identification of a green car. Sometimes all you will have is a letter. Do you think that's enough? Do you think that's enough? If you just receive a letter, I can just write a letter to a police officer, and I can say that you have drugs in your house, and they'll be able to come to your house and search your house just based on one letter, an anonymous letter? I don't know. And that's what the court's trying to get at here. They're trying to define what makes it reasonable. What do you need? What type of facts do you need to be reasonable? We know that Lewis, the facts in Lewis were reasonable. And that's why we have to look at a lot of cases. That's why I wish we had time to look at a lot of cases. And we will be looking at one more case before the semester. The Lewis brothers are gone. We've got new people, new criminals to read about. We've got You got Fourth Amendment issues? Okay. The Fourth Amendment to the U.S. Constitution provides the right of the people to be secure in their possessions. No warrants shall be issued without probable cause. It says it right there. No warrants shall issue, but upon probable cause. So they're telling us that you have to have a warrant in order to search and seize. But they're also telling us unreasonable searches. If you look at the second line in that, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches. So the officers in Lewis, they searched reasonably. They had reason. They were in hot pursuit. But usually the court would prefer a warrant. They would prefer a warrant. If you are conducting an investigation, you better have a warrant. But if you are an officer and you see a crime being committed, then you have the right to chase them, because that's reasonable. And that's what the Constitution is saying. It has to be reasonable. This informant is acceptable as long as the informant's statement is reasonably specific and believable or verified. Because usually warrants and investigations, they deal with informants. They deal with people who call up, hey officer, this is a guy named Bob. Who is this?
Don't worry about it. I don't want to tell you who I am. There's this guy named Bob. He deals drugs. Well, he lives over on Jewett Drive.
Okay, well,
I'll take care of that.
And then the guy
Hangs up. See you. Gotta go. Bye.
That's it. Nothing else. Go get Bob. An anonymous informant. Who is this informant? Who is he? Who is she? The officer needs more than just that, probably. They need the informant to be specific, believable, and verified. So it would be
Hi, is this officer?
Yes, this is officer.
Hey, this is Bob. I don't want to tell you there was a guy named Bob.
Bob who?
Bob Park.
Okay, well, where does Bob Park live?
Well, he lives on Jewett Drive.
Well, how do you know that?
He's a drug dealer.
Where are the drugs?
In his house.
Where in his house?
In the basement. Every Friday he arrives at his house with his wife, and then they drive out, they fly out to Florida, and then they take a car from Florida back to Illinois. Every Friday at 7 p.m.
So he's giving him more details now. He's giving him facts. When, where, regularity. And that's what the court wants. And that's what we'll be dealing with. Handout number 10. I will post that in about an hour or two. Read it for class on Wednesday. It deals with the same issues, but different facts. And we'll be looking at warrants. So have a nice day.